Oh, wait, I need. Good morning, everyone. I'm going to call the meeting to order. I'm the Chair Pro Tem, Kathy Lewis, and this is the Board of Appeals May 9th, 2025 hearing being held both in person in the Hilo Council chambers and potentially by Zoom, although I don't think we have anybody appearing by Zoom so far. I'd like the board to introduce themselves, please. We can start with you, Rachel.
Rachel Abel. Lisa McNamara.
Scott Martin.
And will the board's support please introduce themselves?
Bethany Morrison, Board of Appeals staff.
Deputy Corporation Counsel Sylvia Wan, and we also have Ashley DeVera, the board secretary, in the back.
Thank you. Okay, so we can go ahead. I'll just give you a few ground rules so you know basically how we can get through hearings efficiently. And this pertains to all our proceedings, really. All cameras must be turned on at all times during the on, all cameras.
So all cameras should be turned on if you're participating, but otherwise.
Oh,
be
by
off.
Zoom.
Yes, by Zoom.
Gotcha. I was thinking it didn't make any. Zoom, all right, yes. So if you're on Zoom, please turn your cameras on so we can see who's speaking. One person should speak at a time and try to avoid side conversations that can get disruptive. Mute your device if you're not speaking to improve the audio quality, and that's again for the Zoom people. If you would like to speak, if you could raise your hand, wait for recognition by me before speaking to ensure that the record is clear and clean as to who's speaking. And prior to speaking, please state your name so that all parties know. And speak slowly, clearly, and close to your microphone if you can. We'll try to limit distractions by turning off your mobile phones and any other devices that make noise. All right, as a general reminder for all the board members, including myself, please state your name before speaking throughout the day. At this point, then, we're going to take statements from the public. I'm not sure if we have anybody. Nope.
No statements from the public.
Thank you. All right, so that we'll move on from that. Thank you, Bethany. Now we're going to take care of some quick old business. We'll first call the first case, which is David Heffer, BOA 19-000206-C. And what we're considering here are the findings of fact, conclusions of law, decision and order to deny the appeal based on the decision we made at the meeting of, well, what meeting was that? Our last meeting. All right, so Bethany, I think I know the answer to this, but are there any public testifiers on this?
No
matter?
public testifiers.
So we are here to adopt the findings of fact, conclusions of law and order. And has everybody had a chance to review that? Just prepared by Ms. Campbell. All right, excellent. So I would entertain a motion either to approve it as written or as amended. If you have any amendments to add.
I motion for the written approval. Written
Okay.
approval, yes.
All right, so let's make sure I take this and we need a second first, correct?
Second.
Okay, and all in, no, we don't vote yet. Yeah, we do.
Discussion.
Okay, discussion. Discussion now, please. Any discussion?
Deputy Corporation Counsel Sylvia Wan, I know I'm not a part of the board, and I understand that the motion on the floor presently is to approve as written. I do just want to make one clerical note. As provided, the introductory paragraph does is written from the perspective of a submittal from the department. And if the board is going to go forward with accepting these otherwise findings of fact, conclusion of law, that introductory paragraph would need to change. And so I would suggest, and of course, this is up to a board member to adopt, that introductory paragraph be exchanged for the following sentence. On May 9th, 2025, the County of Hawaii Board of Appeals adopted the following findings of fact, conclusions of law, decision, and order. So that is my form suggestion for the board. But of course, someone would have to adopt that, and the mover would probably have to adopt that as an amendment to your motion, if that's what you so choose.
Rachel Abel, board member. I want to amend for the written approval to have the replacement and the introduction.
Okay, anybody second that?
I'll second.
In discussion? I think that's great. Thank you, Rachel. We'll go ahead and take a vote then.
Yeah, voting on the amendment.
Voting on the amendment. All in favor, say
Aye.
aye. All right, that passes unanimously. I am going to ask Deputy Counsel Jean Campbell to begin submitting these proposals with the fly sheet and the introductory, and then a new fly sheet without that. Then we don't have to do the amendment. All right, we'll be perfect. All
So
right, moving, are we done with that?
not technically.
Okay.
So technically, your motion has been amended to include approval with the one adjustment. So that now is on the floor for the board's consideration,
okay.
and you're currently in discussion. If there's no further discussion, you can move
Gotcha.
on to voting.
All right, any further discussion on the amendment? All right, then we will vote to adopt it as amended. All in favor? Aye. Okay, it passes unanimously. Thank you. That. Okay, that's the end of the old business then. Oh, no, it isn't. We have one more item of old business, excuse me. All right, I'm going to call the case. It's Jennifer Greger, BOA-19-000228. This is on the planning director's motion to dismiss. And everybody have a chance to review the motion? Okay, great. And I will note for the record that there was no submission in opposition to the motion by the appellant, nor has there been any appearance by the appellant. And so, yes, well, for argument.
Yeah.
Yeah, do you want to make a short presentation? Quick argument, I should say.
Good morning, Chair Pro Tem Lewis and board members. Jean Campbell, Deputy Corporation Counsel on behalf of the Planning Department. This matter is one that is an appeal from 2019, and it was following the denial of a short-term vacation rental non-conforming use certificate. As some of you are probably vaguely aware, at the time that the original short-term vacation rental law went into place and the Planning Department began receiving applications for non-conforming use certificates back in 2019. A number of them were denied for a whole variety of reasons. A number of those denials followed up with Board of Appeals appeals. And this case is the very, very last of those 2019 appeals. As you can tell from my motion, and as Chair Pro Tem Lewis just mentioned, this particular appellant hasn't appeared or submitted anything or responded really at all, either to requests for contact from the Planning Department or from the Board of Appeals for quite a long time. It is our assumption that this appellant has essentially abandoned their appeal And so we are asking the board to essentially take it off the docket and just dismiss this as an appeal for the lack of prosecution at this point. Thank you.
Thank you, Ms. Campbell. Does anybody have any questions for Ms. Campbell? Okay, then I would, I would entertain a motion.
Rachel Abel, board member. I motion to dismiss
Okay,
case BOA 19-000228.
I'll second that.
oops, all right, thank you. Any discussion? Okay, it seems, if you want, yeah. if you-
Okay. Deputy Corporation Counsel Sylvia Wan. I will just note from the board staff's perspective that the board has attempted to make contact with the appellant with the provided contact information that the appellant had provided. We also made other attempts to try to identify any alternative or new addresses for the appellant, and were not able to do so. We were also able to mail by certified letter on April 3rd, 2025, trying to attempt to inform the appellant of today's hearing. That letter was returned to the board on May 3rd, and it was marked return to sender, unclaimed, unable to forward. So I just wanted to give that clerical information to the board for consideration.
Okay, well, we'll call for a roll call vote then. Oh, is there any further discussion? I didn't mean to cut anyone off. Okay, thank you, Bethany.
Okay, on the motion to dismiss, member Rachel Abel,
Aye.
member Lisa McNamara,
Aye.
member Scott Martin,
Aye.
Chair Kathy Lewis.
Aye.
Chair, you have all ayes.
Okay, then that passes unanimously. And Ms. Campbell, can you prepare us an order? Thank you so much. Really appreciate those prepared items. Okay, now we are moving on to new business. We have one case before us. That is Beverly L. Fuller, PL-BOA-2024-000115. This is an appeal of a decision by the planning director dated November 13th, 2024, regarding approval of special management area assessment application. That's enumerated PL-SAA-2024-000249 to construct a single-family dwelling and related improvements. The location for this is 28 Machida Lane, Hilo. And Bethany, are there any public testifiers on this agenda item?
No testifiers, Chair.
Okay. Then can I please obtain the names and appearances for the parties in this matter? I'll start with the appellant.
If you can come forward to the mic.
You don't
And-
have to sit if other people are going to introduce themselves, but just speak into the mic. You can lift it up a little bit if you need.
And then
And
just press the button.
speak button there. And you hold it. Oh, no, I guess you don't.
Okay. Beverly Fuller, Beverly L. Fuller.
And you are the appellant, correct?
I am the appellant.
Okay, very good. And is there anybody else here to testify or appear for the parties?
Yes,
I guess maybe we'll wait to introduce them as they're going to come up.
okay.
All right. And from the department, who will be appearing?
Good morning. This is Deputy Corporation Counsel Jean Campbell, and with me today is Planning Director Jeffrey Darrow.
Okay, very good. Now, Bethany, do we know that appellant has provided the notices to the surrounding property owners?
Yes, those notices were provided on April 22nd, 2025.
Okay, very good. Good job. All right, then we're going to proceed with the hearing, and I'd just like both sides to know that we have reviewed the matter and the record. And with that in mind, you don't need to repeat things that we may have already obtained from reading the record. And if either side does start to present any kind of repetitive testimony or anything, I might urge you to move along. There is one legal issue before the board, and that's whether the director's decision at issue should be reversed or affirmed. Okay, so let's begin. I'll now hear any opening statements from the party. Please keep your statements to about 10 minutes. And at 2 minutes, Ms. Wan will announce that you have 2 minutes left. And we'll start with the appellate.
Yes, I have requested that my niece here, Emmeline Renz, read my statement because I'm visually impaired with macular degeneration, and it's difficult for me to read and see.
Okay, well, I'm sorry to hear that, but that is just fine. And you can move the microphone towards the front of the table if that helps you reach it better. Move it around, make it comfortable for yourself.
Hello, my name is Emmeline Renz, and I'm reading the statement on behalf
What is
of
your name?
Emmeline Renz.
I can't understand your last name.
Renz, R-E-N as in Nancy, Z as
Very
in
good.
zebra.
Thank you.
Sorry, it's a complicated
No
one.
problem.
Okay. Thank you for letting me read for her. Appreciate that.
Sure.
And I'm reading her statement, so I will use I as Beverly. I attended the 9/24/2024 Windward Planning Commission Zoom meeting and heard the commission deny the landowner's application for the construction of 3 large homes on Machita Lane. I heard the landowner's representative state that the applicant would go forward with applying for the approval 1 house at a time. Because of this, it is evident that the intention is to build all 3 large homes that were denied. When the landowner returned to the planning commission with the revised application for a single large home only 2 months after the denial, and it was approved, I submitted this appeal based on the following text of Rule 9-1F4 regarding special management areas. Whenever an application, do you want me to read the rule or should I skip that as repetitive?
You don't need to. I think we've all
I'll
been
just
able to
highlight the
review
parts
it.
of the rule that we're concerned about.
Okay, excellent.
So we want to highlight the phrase that no new application for the same or similar development covering all or any portion of the property involved in the application shall be accepted by the commission for a period of 2 years. And this is 2 months. Also, the present application has not shown a substantial change of circumstances regarding the reasons the original application was denied. So as owner of the property next to the proposed development, I am concerned about the impact to the existing residents. We know that this application is just the first of 3 applications from the landowner. If this large home is permitted, it will set a precedent for the other 2 large homes to follow. If these 3 homes are permitted, it will be a 50% increase in the number of structures in the subdivision and a potential 100% increase in the number of occupants given the number of bathrooms and bedrooms in the structure. Machita Lane is a narrow, 1-lane dirt and gravel private road. It is not maintained by the county. Access by large vehicles is difficult or impossible due to sharp turns. A fire truck could not be able to access the structures at the end of the road. Safe evacuation from a tsunami would be questionable, and a solution to the safe evacuation from a tsunami would be questionable. There's also another concern regarding wastewater management. The ground is low and subject to high tide seeping underground. Adding more bathrooms and putting more waste into the ground will pollute the tide pools and ocean of Onikaha Beach. A solution to the access issue would be accessing the property from Lahela Street, a wider paved road that's maintained by the county. But because the rule states that a substantial change of circumstances regarding the reasons the application was denied was not presented in the new application, the second application should be denied. That's the end of Becky's
Thank you.
statement.
All right, we'll proceed with you, Ms. Campbell.
Good morning, Chair Pro Tem Lewis and board members. I'm Deputy Corporation Counsel Jean Campbell. With me today, as I mentioned earlier, is Planning Director Jeffrey Darrow, and thank you for the opportunity to present our case today. This case involves the applicability of the state special management area requirements to the construction of a home on Machida Lane, as you've heard, near the Onioni Kaha Beach Park in Hilo. The family owning the property at issue also owns an adjacent lot on the Mauka side of Machida Lane and a third lot on the Makai side of the same street. To understand this case, we need to begin with the State Coastal Zone Management Law, or HRS Chapter 205A. Chapter 205A establishes areas along our coastlines called Special Management Areas, or SMA, which are the subject of greater regulation and development controls in order to avoid permanent losses of valuable resources and to ensure that public access to our coastlines is provided. Because the focus of Chapter 205A is essentially environmental protections and ensuring public access, a number of factors at issue in other land use determinations are not considered in the SMA permitting process. Increases in traffic, for example, are not SMA considerations unless they rise to the level of becoming environmental concerns. The Mauka boundary of the SMA in the vicinity of the property at issue today is located Mauka of Kalanianiole Street, placing this property well within the SMA district. The type of SMA approval required for any given project depends on the type and the scope of the project. Approvals range from the top end of the regulatory structure being SMA use permits, or colloquially major permits, which are approved by the planning commissions, to SMA minor permits and emergency permits, which are approved by the planning director, and at the lowest end, SMA assessments, which are also submitted to the director for review and determination. The owner of this property, as you've heard, originally submitted an application for an SMA use permit, or major permit, for construction of 3 homes on their 3 lots. The use permit was required because of the scope of the development. The use permit application, as you've heard, was denied by the Windward Planning Commission at their September 2024 meeting. Following the denial, the owners reduced their plans to 1 home and slightly reduced the size of that building. Because of the reduced scope of the project, it qualified for an SMA assessment and no longer triggered a use permit. The director is authorized by the Planning Commission rules to make determinations about SMA assessment applications, which he did in this case. The law does prohibit resubmittal of an SMA use permit application to the Planning Commission within 2 years of a denial, but no second use permit application has been submitted in this case. And the law does not prohibit the submission of an SMA assessment application on the same property. The director evaluated the assessment application and determined, based on a number of factors, which I will let him discuss, including the fact that this is a single-family dwelling and the lot is not a shoreline lot, that the project is exempt from SMA permitting requirements, and he approved the construction of the home. Among the conditions noted in the director's exemption determination is the fact that should any substantial changes or additional phases or activities be proposed, additional review will be necessary and a use permit might be required. Given that the assessment application that the director received qualified for an exemption determination and was not a use permit application, the Planning Commission rule prohibiting resubmission in 2 years does not apply, and the exemption determination was appropriate. The director's decision did not violate the law, was not clearly erroneous, was not arbitrary or capricious, characterized by an abuse of discretion or a clearly unwarranted exercise of discretion. So we ask you to uphold the decision. Thank you.
Okay, thank you. And now we'll move on to hear from any witnesses that care to testify or are here to testify. And Ms. Fuller, do you have any witnesses?
Yes, I had listed a second witness.
Are you going to be the witness right
No.
now?
No,
Oh, okay.
I submit in my witness list, I submitted the name of Denise Colgrove. She recently had heart surgery and she's not well enough to be here. But I'm requesting that my niece Emmeline be able to read her statement as well.
Yes, that will be okay.
Thank you. Yes.
Yes. I think that she should be sworn in a modified way that, to her best of her ability, this is that woman's testimony, the other one, something like. You know, I'm going to stop you for a minute and, okay, very good. We want to swear you in, please.
Yes, go ahead.
Deputy Corporation Counsel Sylvia Wine.
Yes.
Can you please state your name again for the record?
Yes, Emmeline Renz, R-E-N as in Nancy, Z as in zebra.
Thank you. And you're going to present the written testimony of who?
I'm going to present the written testimony of Denise Colgrove.
Okay. And you're going to present that orally today?
I will present that orally.
Okay. So at this time, do you assert before this board that you will tell the truth, the whole truth, and to the best of your knowledge and ability, represent in a clear and concise fashion the testimony of this individual?
Yes, I will.
Thank you.
In regard to this is a statement of Denise Colgrove. In regard to plan number PLBOA 2024-000-115, my testimony as an owner of Onikaha subdivision is in agreement with the other 4 homeowners submitting testimony. Therefore, I will only briefly reiterate the points made when the original application by the Wangs was not approved by the Planning Commission. As you may know, the original application was for 3 5-bedroom houses. The reason we gave for rejecting this application were as follows. The harm to the environment with excess sewage and gray water going into the Onikaha beach and reef systems. The inadequate access to the homes in that Machina Lane is just that, a narrow dirt road with no outlet. The size of the lane with a sharp right turn to enter makes the access of large trucks, such as fire trucks, a hazard in the inability to get in and out of the area, such as if there were a fire or tsunami. As Ms. Fuller said, because the application to build is in a special management area, the rule 9-11F4 is applicable. The rule is restated here. I'll just skip that part because we've talked about restating the rule. Therefore, the application should be denied. I think it is realistic to believe that by submitting an application for one house, only that the Wangs are attempting a backdoor method to ultimately build the 3 original monster houses on their 3 lots. I think we can presume that. Were this procedure to be fulfilled, the original reasons for not allowing the construction still exist. Environmental damage to the ocean, reefs and ocean creatures, and limited access causing danger to inhabitants of the subdivision. This puts heavy use on the Onikaha Beach Park area with the stated plans of the Wangs to rent out the 15+ bedrooms in long or short-term rentals. Do we really want to see Onikaha Beach become a Waikiki? Denise Colgrove.
Thank you. All right, well, I guess cross-examination is probably enough. Do you have any further witnesses, Ms. Fuller?
Yes, the next witness is David Owens, who is also a homeowner on Machita Lane.
Thank you.
This button. Yeah, my name is David Owens, live at 5 Machita Lane.
Good morning.
Hi.
Deputy Corporation Counsel Sylvia Wand, do you promise and attest that you will tell the truth and nothing but the truth before this board to the best of your knowledge and ability?
Yes, I do.
Thank you.
I was at the meeting where the Planning Commission rejected this. It's 15 apartments. It was disapproved. It was quite a heated meeting, actually. Went on for quite a while too. They disapproved it for several reasons, but the 2 major ones that we discussed already, the sewage problem and the road problem, and they haven't changed. Submitting one by one is basically circumventing what the Planning Commission agreed upon. And to do it in one by one like this is still going to damage the environment, is still going to clog the road up. I think we submitted pictures of the road. I have a dump truck I can't even use on that road. It's that bad. And to put 15 apartments on that road just doesn't make sense. I've offered, I own the property behind this project too. I granted an easement so they could access La Hala Street, which is a recently paved county road. They've chosen not to use that, and we're not sure why, but that would have helped. But they don't seem to care about the residents or the neighborhood. They're developers from Oahu, and they just want to build 15 apartments. And I think what they're doing is one by one like this is not acceptable.
Okay, any cross-examination?
Good morning, Deputy Corporation Counsel Jean Campbell. I can't say that. The department doesn't have any, had not even planned any questions for any of the witnesses except Mrs. Fuller. Thank you.
Okay, would any board members like to ask
Yeah.
questions? Witness.
I have a question for corporate counsel. Should the applicant come back for the second and the third construction permit or approval?
Okay, I'm sorry, Deputy Corporation Counsel Sylvia Wan. Hearing the preface of your question, at this point in time, I think it's a little premature because the department has not yet presented their case.
Ah.
And that might be a better question to be presented to the director. Thank you.
Okay, hearing no other questions, then you're excused. Thank you for your testimony. Do you have any further witnesses, Ms. Fuller?
No, I do not. I just submitted the three
Okay.
witnesses.
All right, now just remember that you are able to cross-examine the department's witnesses. If you like, you can just stay seated. All right, go ahead and present your witnesses.
Good morning, Deputy Corporation Counsel Jean Campbell. We do have one question for Mrs. Fuller. What is your aim in filing this appeal? What is your hoped for outcome?
The hoped for outcome is to have the landowner agree to use the Lahala Street access to avoid congesting Machida Lane and causing more use and damage to the road that the homeowners on the street have to maintain this road. And whereas Lahala Street being a little bit wider and paved and maintained by the county is a better choice.
Okay, thank you. We don't have any further questions.
Hey, you can just stay there if you like.
Okay.
Do you have any witnesses to present now?
We do. I'd like to call Planning Director Jeffrey Darrow, please.
Okay.
And Chair, I'm sorry if I might, since there's only two mics, I would ask so that we don't have to share, they don't have to share. If
Oh, I
Ms.
see what
Fuller
you
could
mean,
sit
yeah.
back and
Right.
then the questioners can just swap seats.
Yep, yep.
Right, thank you.
I can
Makes
relinquish
sense.
my seat when it's Mrs.
Right,
Fuller's
right.
time to question.
I wasn't thinking very logically there.
We're not used to this setup. We're used
Yeah,
to
yeah.
where we have more microphones and more space. Okay. Can I ask you to introduce yourself? Or actually, I suppose he needs to be sworn in?
He does. Deputy Corporation Counsel Sylvia Wan, can you please introduce yourself?
My name is Jeff Darrow, the Planning Director with the Planning Department.
Thank you. And do you at this time attest and affirm to tell the truth and nothing but the truth before the board to the best of your knowledge and ability?
I do.
Thank you.
Okay, thank you. Director Darrow, can you briefly describe for us the difference between the SMA assessment process and a use permit? So what kind of projects trigger one versus the other?
Sure. First of all, good morning, Chair Lewis and members of the Board of Appeal. Jeff Darrow with the Planning Department. The difference between a special management area major use permit mainly comes from.
Sorry, can you push the mic just a little bit back? We're getting a
Okay,
little breath
too much?
feedback. Thank you.
Usually is a matter of cost, but it also has to do with whether or not it qualifies or does not qualify for one of the listed exemptions under state law. And there's quite a number of them. It's not just one or two. There's probably 20 of them. When we look at an application, first of all, we determine whether or not it qualifies for one of the exemptions. If it does not, a majority of the time it becomes an issue of monetary value. Right now, the limit is 500,000. If it's lower than that, the department can issue what's called a minor permit. If it's larger than that, it will need to go to the Planning Commission for an approval. And just a caveat, that recently has changed with the legislature. My understanding that the value has gone up to 750,000 for that, but it still does not apply to that. It's still 500,000 for parcels along the shoreline.
Thank you. So I think I'm gonna kind of squish several of my next questions together into one because I think this has mostly been covered. But just to clarify and confirm, this property together with its two adjacent lots was submitted for a use permit application last year, correct?
It actually came in as an assessment, and when we reviewed it, the way that this particular exemption is identified in state law and within our Planning Commission rules is construction or reconstruction of a single-family residence that is less than 7,500 square feet floor area is not on a shoreline parcel and is not part of a larger development. So this particular application that came in with 3 dwellings on 3 different parcels was what we considered part of a larger development. And so we did not exempt them. We asked them to go before the Planning Commission for an SMA major permit.
Okay, thank you. That's helpful. Given that the Windward Planning Commission denied the use permit that was submitted to them last year at their September meeting, would this applicant be able to come in with a new use permit for anything, essentially, any substantially similar project on any of these 3 properties as a use permit?
Based on the Planning Commission rules, they would have to wait a period of 2 years before resubmitting a similar use SMA use permit application.
Okay, great. So just to make sure that for the record, we do all recognize that no new use permit can come in the next 2 years from last September. So shifting to the assessment application that you received that's at issue in this appeal, what factors did you consider in your review?
The main factor we look at, excuse me, is whether or not this particular request qualifies for an exemption. We're just looking at the SMA at this point. We're not looking at all of the different areas that a building permit looks at. We're looking at whether or not this particular request is exempt, if it needs a minor permit or a major permit. In this particular review, it qualified for one of the exemptions.
Okay, and does your exemption determination letter make clear to the landowner that should they come in with any additional phases, substantial changes, essentially anything bigger and more, to get right to the point, if they came in for the next 2 houses, would those be determined to be exempt as well?
A typical part of our acceptance letter or approval letter for a SMA exemption letter states that if this changes, if it increases, or if it's expanded, they will need to submit another SMA assessment application. In this particular case, there's been discussion about this is a way to circumvent the law. We still will look at it similar to how we looked at it before. If the same applicant or same owner comes in and tries to circumvent the law through submitting several assessment applications for single-family dwellings, similar to what they originally did, we will ask them to go before the Planning Commission. This is not a common or a usual type of activity. It occurs every so often, mainly with developers. They'll come in, they'll do a subdivision, and they'll want to build several dwellings. And we'll tell them it does not qualify for an exemption because you're doing part of a larger development. So we will direct them to an SMA major permit. What they can do is they could create the subdivision. That in itself could also trigger a major. But if it doesn't, then they could sell the lots, and then each individual owner could come in and they would most likely qualify for this particular exemption, similar to a majority of the people that build their single family dwelling in the SMA.
Great, thank you. And one last sort of SMA specific question. So the assessment application that you received following the denial, was that one processed essentially consistently with the way that the department processes SMA assessment applications for single family homes island-wide, and in particular, any that may have come in on Machita Lane?
Yes.
Okay, great, thank you. So shifting now to the environmental concerns that were raised about the application itself. The treatment of wastewater was raised as a specific concern. Can you tell us how wastewater is addressed for this project?
So normally, we'll go back to the SMA major permit. So when they submitted an SMA major permit, part of our responsibility is to send out the application to numerous agencies and request their comments. And we did that, and we received comments. Those comments are usually incorporated as part of the permit conditions. In this particular case, again, the SMA major request was denied. When a single family dwelling comes in the SMA and is reviewed by the department, we're looking mainly at the review of whether or not this is an exempt action, whether or not it requires a minor permit, or we ask them to submit to the Planning Commission for a major. In our review, we don't send it out for agency comments. We just we utilize the exemption that was granted by state law. When they come in for a building permit, that's when they will go through the agency reviews for wastewater, for water, for access, and for the process of the single family dwelling.
Great, thank you. Is it the State Department of Health that actually regulates how wastewater is treated at an individual property like this?
It can be. Most times it is, if it's not connected to the county sewer. If it's the ability to if there's the ability to connect to the county sewer, it would go to our Department of Environmental Management.
Great. So apologies. I don't recall whether there's sewer service available at this property. I think there is not.
My understanding is there's sewer in the area, but there's significant improvements that would have to be done.
Okay.
But again, that would be a determination made by either Department of Health or DEM at the time.
Okay. So if it were the case that sewer connection was not feasible, the Department of Health would be the authority to require some sort of wastewater treatment for the property.
Correct. And I mean, just to add upon that, there's been discussion about impacts of septic systems. So they have in their rules as well areas that they address that particular issue. If it's so close to the shoreline, they have a distance that you cannot put in that type of septic system. They have other options that are available to homeowners to be able to protect the environment when those particular issues are triggered.
Great, thank you. All righty, I think that's sufficient for environmental concerns. So the access concerns about the ability of Machida Lane to be able to accommodate additional traffic. Can you tell us how access and traffic are addressed in the SMA process?
Unfortunately, that's not a consideration, as you had mentioned originally, in regards to the SMA assessment review in the department. It also is not a trigger for review, even with a major, unless it rises to the level that it's going to have a significant environmental or ecological impact, which normally it doesn't. An example is if and this has been challenged. There's court cases that have ruled on this particular issue, and we do include that information within our SMA major permit background report. But basically, normally for a particular application, there will be a comment letter from Department of Public Works or from Department of Transportation asking for certain roadway improvements for a request. In an SMA application, that's not an area that we can put in conditions unless we can connect it. There's some sort of nexus between the SMA and impacts to the SMA regarding the requested improvements. I haven't seen that happen very often. The only time I've seen it was probably 10 years ago. And maybe it was longer than almost 20 years ago. I'm sorry. And again, that was a determination that the planning director had recommended to the commission on Ali'i Drive, and it had to do basically with the traffic going into that particular development may have an impact on people being able to get out in a tsunami evacuation particular event. And so the planning commission agreed and they ended up including it. The applicant could have challenged, but they did not.
Great, thank you. So given that Oneonekaha Beach Park is really nearby, is there an anticipation that construction of this home would affect the public's access to the beach park?
That's always a consideration. Public access is one of the main issues. The other is lack of public access or blockage of public access. In this particular case, that wasn't a factor.
Great, thank you. Those are all the questions that I have for the planning director. I'll yield to Mrs. Fuller, who may have questions.
Okay, I'd like us to be able to question you as well, and I'll start off, I guess.
Well, I'm sorry,
Oh,
Chair.
Yeah,
We
Oh, yes,
need
Mi-
to allow Mrs. Fuller first. and then the board.
absolutely. Thank you. Ms. Fuller, do you want to cross-examine the witness?
This is on.
Yes.
Okay. The only question I would have is that talking about road improvements, there's really no space for any road improvements on Machida Lane. The homes are basically right on the edge of the road, so there's no way to widen it. And I don't know if you saw the exhibits I submitted about the pictures.
Speak into the microphone.
I sent in pictures of even the garbage truck coming into the road. They have to back in and they have about 3 inches on
Do you
each
have a
side.
question for the witness?
Well, the question is, he was talking about road improvements and I would wonder how Machida Lane could be improved given the condition it's in.
Thank you, Ms. Fuller. The The testimony I was providing was that in an SMA review that results in an exemption, we really don't have the ability to provide conditions regarding those types of improvements. This would be, it could be considered in an SMA major permit, similar to what was provided earlier to the Planning Commission, but even they have certain limits on when they can condition roadway type improvements in an SMA permit.
Thank you.
Okay, now we'll take, okay, all right, you're raising your hand. What is it that you'd like? Well, I'll tell you what, you consult with Ms. Fuller and she'll ask the question. Yeah, you consult with Ms. Fuller, she'll ask the question.
Yes, I'm sorry, because according to the board rules, there can only be one representative. Thank you so much.
I want you to ask and clarify that.
Okay, the question is, were the wastewater concerns and access concerns considered with the major
Permit.
development?
It's not on whether or not the use permit denied by the planning commission, whether that denial is valid.
Okay.
You have a valid point.
So I'm sorry, just because Ms. Campbell was off mic, I'm going to try to repeat what she just stated for the
Okay.
record. My understanding is that Ms. Campbell entered an objection. The basis of the objection was that the question is outside of the scope of the current petition because it refers to the SMA major application, which is not at issue before the board.
I'm going to allow that though, because I do think the theme of this case is whether we're trying to circumvent what was done at the at a major SMA. So you can go ahead and briefly answer that.
Oh, thank you. So in the SMA major permit, they did evaluate that, and that was, they had several reasons for denial. Those were part of the reasons for their denial. And again, it was based on the fact that this was an SMA major permit, and it was not falling under one of the proposed exemptions under state law. And again, just because a project is exempt under state law does not mean that it's exempt from having to do all of the necessary improvements for that particular development that's being exempted, mainly single-family dwellings. Every single-family dwelling that is approved under an exemption still has to go through the building permit process, which includes wastewater, water, and your construction requirements.
Okay, any further cross-examination? Go ahead and confer.
Another reason that
Are
the,
you going to ask a question of the witness?
yes.
Okay. Thank you.
I'm trying to think about how to
Sure.
phrase it. Is this home actually a single family home? I have looked at the plans for this structure, and it looks like it's more of a hotel than a home to me.
The requests that had come into the planning department was for a 4-bedroom, 4-bath, single-family dwelling. There was no request for a duplex or a multifamily dwelling or a hotel.
Do you consider the layout of the house when you're looking at the plans?
Yes,
At the application, yes?
right.
Does it make sense to have a water heater and a washing machine set up in the living room?
Again, it in regards to the zoning code and the definition of what we define a single family dwelling, it meets the definition of a single family dwelling. If there were multiple kitchens within the house, that would be a clear identification to the planning department that this is set up as multifamily dwellings or hotel use or something. I believe in the original application, they had clearly stated that they would be utilizing the dwelling for vacation rental or short-term rental, which is an allowable use.
Sorry, Deputy Corporation Counsel Sylvia One, I'm just gonna ask you to direct, because that kind of went off of her question, can you direct it back to the present assessment?
Yes, again, the only thing that's requested is a single-family dwelling.
The bathrooms, the 4 bathrooms are actually en suites to the bedrooms. If there are guests there, do they go into one of the other rooms to use the bathroom? To me, it looks like they're planning to build more bathrooms and bedrooms where they have currently placed the washing machine and water heater.
Yes, unfortunately, this is a common issue that the planning department deals with on a regular basis, where we can project that there's the possibility of something happening, and we definitely are aware of these particular issues, and we try our best to try to not let them happen. But when it's clear that they have not crossed a particular threshold where they are multiple dwellings or duplexes, we're basically we have to believe what the applicant and the plan has shown.
Does the planning department look at the size of a lanai, for instance? This plan shows the lanai is only 4 feet wide.
Yes, we do. I mean, that's just, again, whether it's 4 feet or 40 feet, it's not something we take into consideration
Not a
with this.
consideration. Okay. Thank you.
Thank you.
Okay, questions from the board members, please? Oh, I'm sorry, yeah. Yeah. So, questions from the board members? Good. Scott.
To the planning department. When the applicant comes back in for the second and third dwelling, at that point, it's going to likely be an assessment and not a major use. Correct?
I mean, they could come in with an assessment, but we've already expressed clearly in this approval letter that if they come in similar to how they came in originally with the same owner, and this similar type of request, even if it's a single family dwelling,
Right.
we would trigger it as needing a major because it's part of a larger development.
So they would need a use permit, not an assessment permit.
Correct.
Which would trigger a tougher criteria for approval. Because you're going to consider all 3 properties as a major use.
If they just came in with one additional dwelling, then at that point, they would be looking at the two dwellings at that point,
Who's they?
the planning commission. So what would happen is this approval really is just for one dwelling.
Right.
If they come in again with a second dwelling, that's really what they're looking
Is there a
at.
time period that you affix to when they come in for the second and third?
Well, it sounds like based on the rule, they couldn't really come in for another use permit until 2 years. But if you're asking how much time before that is no longer considered a major permit,
Correct.
if it's the circumstances remain the same, we would look at it as a larger
So
development.
there's really no time limit then?
Correct. Either they can, you know, I'm not sure why this particular applicant chose to want to build 3 dwellings as, you know, him being the owner. It could be. And again, at that point, we look at it very similar to a developer that comes in and is doing a larger development. So if that's the case, that's how it's going to be assessed. If he ends up selling the other properties and that becomes a new owner and they come in for an assessment, it would be falling under this exemption.
So it would not be considered a major use permit
Correct.
if there was a different owner of the
Correct.
property coming in?
Each one of the owners on Machida Lane
Mhm.
had the same allowance given to them.
Right.
There's even a duplex across the street from this particular applicant that he received the exemption for the first dwelling and he put in a duplex and the duplex was assessed. It didn't reach the level of requiring a major permit, but it did receive what we call a special management area minor permit.
Or all, with respect to the second and the third lot applications, has it been clearly delineated in writing to the
Applicant,
appellant?
Yeah.
That these conditions would exist as you've described?
they're in our application for approval, the approval letter.
Okay.
Council Campbell had referred to the information that's in there.
Okay. So the
So
time,
basic-
the time limit,
There's no time limit.
okay.
Yeah, again, if they were to come in to do the same project again, they would have to wait 2 years. But if they try to come in and do an assessment and it's beyond 2 years and it's the same circumstances, we would say it's part of a larger
Right.
development.
Okay. No more questions. Thank you.
Thank you.
Okay, I have a few. Is part of the assessment process consideration of the intent behind the SMA? Assessment.
I'm
In
sorry.
other words, in part of the assessment process, do you, since I don't know, do
Sure.
you take a look at whether the project is consonant with the intent behind the special management area?
Yes. I mean, again,
Excuse me.
the intent of the rules and laws of the SMA in regards to single-family dwellings is that they are not considered development according to their rules. Therefore, they're exempt.
Okay,
So
but there are single-family dwellings and there are single-family dwellings,
they
okay?
they're
I
all
think we're
the
seeing
same.
that, so, given that, are you precluded in any way from looking at the scope of the building and deciding whether it is consonant with the intent behind the SMA?
We are given a limitation, and that limitation is 7,500 square feet.
And $500,000.
No
I thought
value.
we talked about,
No, the value is only when a project is deemed as development. In this particular case, the exemption is not defined as development. So the limitation that state law has put on is the size of the dwelling of 7,500 square feet. Yes. And we don't come across those very often. Normally, you'll find those in the resort zones that are covered under SMA major resort development permit. So, but in this particular case, the request is for an approximately 4,000 square foot house with 4 bedrooms and 4 bathrooms. We have, if this particular request was on a shoreline parcel, then we would look at it, because in the definition of the exemption, or in the identification, it says it does not apply if you're on a shoreline parcel, and it does not apply if you're part of a larger development. So in this case, it's not shoreline. Now it's not part of a larger development.
Right.
And it's less than 7,500 square feet.
What is the wastewater situation, for example, on Appellant's house? What's going on over there? And I'm asking the director.
Yeah, I'm not sure about where Ms. Fuller lives. I did look at the recent approval, or the approval in 2014 for the duplex across the street, and that was serviced through a septic system.
Okay, with whatever amount of setback it needs from the
Correct.
shoreline. Okay.
These
So
are,
none of these people are on that lane. Do we know, either one of you know whether anybody is on cesspool?
I do know that. I think most of the houses are cesspool. When the county was putting in the sewers to the beach park, we requested that we be hooked up to the sewer line. But we're told that the wastewater system is already overloaded and we wouldn't be able to join.
Yeah, I believe that.
So that's where it is.
All right, my last question then is, what kind of checks are in place? Just remind us, who would Ms. Fuller or any of her neighbors turn to if this does turn out to be a fourplex?
they would just contact us. We have a fillable complaint form on our website. We receive these types of complaints on a regular basis, and we do enforce them.
And so they would be halted from using that as a 4-family or 4 different units.
We do we send out a courtesy letter first, informing the landowner or operator, we've received this complaint. We're asking for you to contact us and let us know of a time we can do a site inspection. We then do a site inspection. Based on the results, if we find that the complaint is valid, we issue a violation notice. And in there, it will have fines as well as proposed actions.
Right.
Normally,
we're familiar with those.
Yeah.
Okay. So that is the check on the variance from the plan. And also within the planning stage, if you know the answer to this, then is there a sort of a check on that as well as they're inspecting the building of the building? If it looks like they're varying from the plans, will that be?
I'm sorry to interrupt.
No, will that be a part of the process?
It wouldn't be the planning department.
Right.
Yeah, this would be, this is located in a resort area, believe it or not. I mean, according to the general plan, as well as all of these properties are zoned resort.
Okay.
So they're not just single family dwelling zonings. Normally in that type of zone, we do have what we call plan approval that somebody goes through. But if it's just a single family dwelling, those do not need to go through that. So what it would be is they would come in and go through the building permit process. it would come to us for review, and we would look, seeing if they're in the SMA, if they were reviewed through this process, and then it would go through all the different checks.
Okay, I guess you didn't understand my question. I probably didn't ask it very clearly. If you know, does the planning, does the building inspection process note and require some remediation if they vary from the plan?
If, my understanding is if they submit a plan and a building inspector inspects it and it's not built according to the plan, they won't sign off on the inspection.
Okay,
Yeah.
thank you.
Deputy Corporation Counsel Sylvia One, can you please clarify, Director Darrow, who would be in charge of those inspections? What department?
That would be the Department of Public Works Building Division.
Thank you.
Any further questions from?
Yeah, I got a question. Is this particular property, the second and third, as well? Are they subject to short-term vacation rental, permitting?
They would, because this is located within a resort zoning district, it is a permitted use. They would need to register with us.
Okay, it's 4 bedrooms. Did the plan, I haven't seen the plans. Did the plans include, areas for parking?
Yes.
For how many vehicles?
I'm not sure exactly how much. It's underneath. The first floor is all parking.
Looks like it's for 4 places to park.
Okay, so
Plus
4 vehicles times
4
2
vehicles
more
into the house.
units. That's 12 vehicles on this piece of property.
I'm just, Deputy Corporation Counsel Sylvia One, I'm just going to caution the board member from making pontifications about something that's outside of the scope of this particular petition.
Okay,
Thank you.
If I could interject.
I'm good at pontificating.
So normally, planning department takes care of planning or parking requirements. So for a single family dwelling, you're required 2 parking spaces. If you end up doing a short-term vacation rental, it's going to require more parking. And they're going to have to identify that when they come in for the registration.
Okay, so with this particular piece of property, you've identified that they need 4, they need to accommodate for 4 vehicles.
I haven't done that. Ms. Fuller mentioned there were enough spaces for 4 cars. But in this particular case, they have 2 for the single family dwelling.
For the record, simply, I'd like to object to this line of questioning. It appears we're talking about parking, which is outside the scope of the SMA permit and assessment determination that's before us. Thank you.
And Deputy Corporation Counsel Sylvia One, I'm just going to also make a friendly note to the board. As provided by the testimony by the director, what we're talking about now is not within the kuleana of the Department of Planning, but within the Department of Public Works. Because they're the department that deals with actual building permits, what would be required as far as parking, and what would be needed as far as the specific use of that particular property. Again, all of that is outside of this particular petition and this particular director's responsibility. Am I correct?
If I could interject.
Oh, is there something where I was wrong? Please.
Well, not wrong, but Department of Public Works Building Division takes care of the structure. So when they come in for plans, the inspectors show to make sure they built according to the plans. When they come to planning in the building review, we look at things like setbacks, height. We also look at parking. That's part of our kuleana. The other thing is if the property is located within the SMA, which this is, they look to see if there was a review done to make sure it was. Ironically, in this particular case, and many others, there is a allowance for what is called a short form assessment, and that's in the rules. And what that means is that if somebody is not on the shoreline and they're just building a single family dwelling, they could come and submit the building permit and go through the building process, come to the planning department, and when planning looks at it and sees that they're not shoreline, that they qualify for one of the exemptions, mainly the single family dwelling, they have a form that our staff fills out and exempts them and allows them to move on. In this particular case, the applicant did not do that. They submitted the assessment instead. So we responded to the assessment, but they could have very well just gone forward. Now, again, if they would have tried to do that again, we would have caught that and said, nope, you've gotten one exemption. You cannot get two or three in that case.
Yes, go ahead.
Lisa McNamara. Are either of the other two lots on the shoreline?
None of the lots along Machita Lane are on the shoreline. All of Onikaha Beach Park fronts their lots between them and the shoreline.
All right.
Could I ask a question, please?
Well, would you, Ms. McNamara, would you ask Ms. Fuller the same question?
Are any of the other lots on the shoreline?
One of the lots is closer to, right on the beach park. And the other two lots are, one is next to my house, and then the second one would be next to that house. And then the other one in front of that house, right on the beach park.
But the beach park is the buffer between the shoreline and these lots.
Yes,
So they're not on.
but it's
no one's
not right on the shoreline, but it's as close as you can get there. And the high tide, I know the high tide comes up even into my property. Right in front of my house, there's a pond, and that gets, we see the tide in that as well. And
Further
that house in front of me is on the pond. I mean, on the beach park as well.
Okay, any further questions?
I had another question for the planning
Well,
director.
okay, we're done with that part of the
Oh,
hearing.
okay.
I'm sorry. I think we probably are ready to enter into the motion and discussion. Now, we typically limit these hearings to about an hour anyway, so. All right, I would entertain a motion on this matter. Is anybody prepared to make a motion? Do we need a little quick break?
Yeah, so Deputy Corporation Counsel Sylvia One, just to remind the board, if you do need some time to formulate what your motion would be on this case, you're more than welcome to take a short recess in order to utilize that time in order to draft your motion. I'm also more than welcome to assist any individual member in helping you formulate.
Would everybody like a little, why don't we take a 10-minute recess? Everybody can use it, I'm sure. Thank you.
So
Is
Chair,
there
that
room
would be,
we can-
so are we recessing now, Chair?
Oh, yes, I am sorry. We are
So it's
recessing.
presently 10:50, so we'll return, I'm sorry, 10:51, so we'll return at 11:01.
Okay.
Thank you. Yeah.
Ashley, do I need to do anything special or, okay. All right. Thank you, everybody. We're back in session. And we're continuing with the Fuller case. And I neglected to allow each side to make a brief closing statement. I'd like you to try to keep them to about 5 minutes each. And so, Ms. Fuller, I know you're not prepared. I'm sorry. Would you like to make a closing statement?
I think I've presented everything that I wanted to present. uh, and have sent in the exhibits and done all the due diligence. So I think that, yeah, that's it. I'm not against having houses built there. It's just the intention of the house and the way it's going to look and the number of people it's going to accommodate and the number of bathrooms, things like that.
Okay, thank you.
Yes, thank you. And I wanted to say thank you to Sylvia for forwarding my exhibits. I mistakenly sent them to you, and I appreciate it very much that you sent them on.
No problem. Thank you.
Apologize about that.
Okay, Ms. Campbell.
Good morning again. Deputy Corporation Counsel Jean Campbell, thank you for the opportunity to make a closing statement. I'd like to remind the board that the scope of the appeal is really the only question before us today is, did the director's decision to determine that the application before him for one 4-bedroom single-family home on a resort-zoned non-shoreline lot was exempt from the SMA permitting requirements? He examined the applicable law and properly determined that it was. In his determination letter, he stuck to his scope of authority, and he did not add requirements about relocation of vehicular access because that's outside the scope of the SMA and outside his scope as a director. To ensure that the property owner could not sidestep the law, the director also notified the owner in writing that additional development would trigger additional permitting. Whether any of us believe that a 4,000 square foot home with 4 bedrooms and 4 bathrooms is too big is not applicable. Incidentally, my home is a quarter of that size, so I feel like that's big, but that's not relevant. It's permitted by the resort zoning, it's permitted by law, and it is below the 7,500 square foot trigger that's found in state law in the definition of development. So I ask this board to remember that whether we like a project or not is not the relevant question before you. The relevant question before you is my usual mantra. Did the developer's decision violate the law? Was it clearly erroneous? Or was it arbitrary and capricious, characterized by abuse of discretion or a clearly unwarranted exercise of discretion? And in this case, I offer that it obviously was not. Whether we like the project or not, it was a legal decision, and that's the scope of the board's authority. Thank you.
Thank you very much. Okay, now properly at this juncture, I will entertain a motion on this matter.
Rachel Abel, board member. I move to motion to affirm the planning department's decision in PLSAA 2024-00249 dated November 13th, 2024. I find the decision was not clearly erroneous, and the decision was not arbitrary or capricious, nor was it an abuse of discretion based on the fact that the planning department did follow the law and undergoing SMA assessment when they found the project to be a single within the scope of what defines a single family dwelling. And therefore exempt based on the criteria that it was less than 7,500 square feet and the other requirements that the county made their decision on.
Thank you.
And on a side note.
Well, you want to wait to discussion for your
yeah.
side note? Do I hear a second?
I'll second that. Lisa McNamara.
Okay, we're open for discussion. Rachel?
I just want to say I really appreciate your passion and the kuleana you have for your community and wanting to do the best for our Aina and future generations as well. And I just, hope you are able to get your voice to appropriate people and make, save your neighborhood and keep it. Yeah.
Further discussion?
Rachel, would you also like to provide a sentence or two to support your motion? Maybe further elaborate on it?
Yes. So as far as the planning department, they received their paperwork from the project and it met all the requirements defined by Hawaii state law to meet the single family dwelling. And
Further
that's
discussion?
kind of, yeah.
I just would like to just say I echo Rachel's concerns and yours, all of yours. We understand your theory, and we're just going to hope that the sworn testimony that was given by the director today and in the letter will be the benchmark for this going forward. And we thank you for your doggedness and continuing. I hope that continues as we'll see what will develop here. But unfortunately, our scope of review is very limited, and I have to agree that there was no clear violation of law nor an abuse of discretion. The question is really with the legal framework that we're applying here, and that needs to be taken up with the legislature, unfortunately. Any further?
I would just encourage you, regardless of the decision that comes out today, to keep an eye on the second and third lots and make sure that, that doggedness that you displayed today continues as the developer either moves forward as a single project or a couple of associated projects, or the land gets divided in individual applicants make their way through the planning department.
Okay, with that, I think I'll call for the roll call vote.
Okay, on the motion to affirm the planning director's decision, member Rachel Abel,
Aye.
member Lisa McNamara,
Aye.
member Scott Martin, Chair Kathy Lewis.
Aye,
Chair, you have all ayes, unanimous.
thank you. And again, thank you so much. Really do appreciate it. All right.
So at this time, do you want to set dates as far as the preparation of the order, Chair?
Okay. I didn't set dates with the other one, but
Okay, so at this point, Deputy Corporation Counsel Sylvia Wan, I'm going to request the prevailing party of the department, if you could please prepare a form of the order due on May 23rd, 2025, and the appellant, who's now
Oh.
leaving, can prepare any objections to that form of order, say 7 days after, which would be a due date of May 30th, 2025.
Thank you. I'll take care of that.
Thank you.
all right. Well, we're moving on now to more or less controversial matters, which is the approval of the minutes. I'd like to approve the minutes of the December 13 Board of Appeals hearing transcript. Is there any public testimony on these?
No public testimony.
I'm going to move ahead with each item then, and you let me know if there is public testimony. We'll assume there is. Okay, has everyone had a chance to review the transcript for December 13th, 2024? All right, I would entertain a motion to approve that.
I'll make a motion to approve the minutes of December 13th, 2024, Board of Appeals transcripts.
And the transcript, all right. So we're going to do the minutes and the transcript at one? Is that what you
I
like?
believe this is just a transcript. Is that correct?
Have we already reviewed the minutes on this one?
Yes. So
Okay,
this
so-
one, this is a transcript being prepared for a potential appeal.
Sure. Okay, so this is just the transcript. So, all in favor?
I'm sorry.
Aye.
I'm sorry, did you get a second?
Oh, I thought we did. I'm so sorry.
No. So the motion is to approve the December 13th, 2024 transcript.
Okay,
Can we
second.
please have a second?
Second.
Okay, and all in favor?
I'm sorry, now you need
Aye.
a discussion.
Aye.
And, discussion? Sorry,
None.
folks.
None.
Discussion, none. Hearing no discussion. All in favor?
Aye.
All opposed? And hearing none, it passes. I always forget discussion. Darn it. All right, now we're moving on to another transcript only. All right, that's the January 10th, 2025 Board of Appeals hearing transcript. We're hearing no public testimony. Has everyone had a chance to review that?
Yes.
All right, then I would entertain a motion.
Rachel Abel, board member, I make a motion.
You
I move to motion.
to approve. Any second?
I'll second it.
And any discussion? Hearing no discussion, all in favor say aye. Aye. Any opposed? Hearing no opposition, that passes. And moving right along to approval of the February 14th Board of Appeals hearing minutes and transcript. And hearing no public testimony on the item. Has everyone had a chance to review said transcript and minutes? And can I get a motion?
I'll make a motion to approve the February 14th, 2025 Board of Appeals hearing minutes and transcripts.
And anybody second?
I second.
End discussion. Hearing no discussion, all in favor, please say aye.
Aye.
Aye. All opposed? Hearing no opposition, the motion passes. And now moving on to administrative matters, we apparently have to elect a chair and vice chair for the remainder of the year. Do we have hearing no public testimony on this item? I open the floor for nominations for chair and or vice chair.
Yeah.
All right, somebody.
Sorry, do I hear a nomination?
I nominate our pro tem
All
to
right,
continue in her current capacity.
I'll
as
second it.
chair.
okay, discussion.
Well, Pro Tem Chair Lewis, do you accept that nomination?
I do, I've moved and my life is a little more settled now, so I would, but I'd like a vice chair. So
Okay.
that if I'm sick so any nominations, I nominate Scott.
All right. So at this point, I'll just note, Chair, that there is presently one nomination on the floor.
Oh,
That nomination has, since you've accepted it, can we have a second for that nomination?
I'll second Kathy's nomination.
Okay, and moving along, now that has been seconded, is there any discussion on Pro Tem Chair Lewis retaining her seat? Seeing no discussion, now the board members can vote on the nomination of Ms. Lewis as chair.
thank you. I wanted to squish it all together, but. All right, all in favor, say aye.
Aye.
Aye. And all opposed? Hearing no opposition, I am now the president.
Let's not elevate us too far, but congratulations,
Yeah,
Chair Lewis.
I'm so honored. And do we hear any nominations for vice chair?
Can I ask what that entails?
It entails basically just doing what I do. And you've seen how well I do that. when I'm sick or something happens. And, and you.
Yes, can you please put your mic
Yeah,
on just
Oh,
so
yeah.
everything's
And
recording?
I do, is this the right time to speak a little more? Or should I wait till discussion?
Okay,
Well,
so I can provide a little background for
Okay.
you. So Deputy Corporation Counsel Sylvia Wine, as far as when it comes to roles of vice chair in relation to chairmanship, you would otherwise step into the position of chair if for some reason the chair becomes indisposed or otherwise has to conflict out. Now, please know that you do have resources available to you, that being me. I can train and assist you. I also can provide you handy little cheat sheets to remind you about things along the way. Yes, and I would say it's a great training opportunity, especially if you're considering wanting to potentially be chair in the future, because it's a low pressure way to kind of learn about the process, and you have assistance and support in the background. Okay, so if you are interested, I would highly suggest you to nominate yourself.
As far as time constraints, how much time would be considered to be needed to put into this? And that's what I want to consider just based on my, schedule and things like that. If I do accept it, I just want to make sure I would be able to give it the amount of time that it needs.
Completely understandable. So, generally speaking, the behind the scenes administration of Board of Appeals tends to have a lot of leeway, a lot of lead time, if you will, as far as deadlines are coming across. And as long as our chair provides good communication as far as like when they'd be unavailable or not, which I can just say from experience, Chair Lewis does, then there's really not that much time commitment. And and the amount of time commitment that would be necessary, you would be forewarned about.
Okay.
the other thing is that if you'd like to learn more about what happens behind the scenes, you can be on the Zoom calls at the pretrial conferences, a couple of those. We do get motions that I have to rule on, and if you'd like me to involve you with that, I'm happy to do that. So you can see how, I mean, for the most part, I'm going to be available to do those
Okay.
because they don't have to be on a certain day.
Okay.
But it could be that there's something that would come up. And then, of course, then you have Ms. Wand. And you can see how I struggle, it's.
Yeah. But yeah, you're really good at directing them though. And that's where I feel like where my shortcomings may come from because I don't know where to interject legally in the process.
And I can assist you with that.
Okay.
And so did, and the council do as well, the county,
Okay.
And it's not a perfect world.
And if it doesn't work out, I mean,
We
You're
can
fired.
always hold another nomination. So, based on this very lengthy discussion, do I hear a nomination?
I feel I hear a nomination. I would like to nominate.
I'm
Rachel.
sorry, say that again.
can't nominate myself.
You can.
She can't,
Oh.
but I want to nominate her.
Okay, good. Do it.
I would
Please.
like to. I would like to nominate Rachel to be the vice chair. Do I hear a second?
Second.
I'll second that.
Wow, guys, thanks.
Any discussion?
I'm assuming you accept that nomination, Rachel.
Based on our discussion, I do accept the
She's reluctantly
nomination.
doing it.
Okay, so it's been moved, it's been
Very good.
seconded, it's been accepted. Discussion? All
No.
right, vote?
Aye.
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 All right, you were resoundingly. Ben, elected vice chair.
You too. Congratulations, Vice Chair Abel.
Chair.
Thank you.
All right.
And now finally, 2 announcements. Any announcements? I think we do have one.
Yes, we do have one. Just a moment. Let me see my
All
note
right.
here. I just want to let the board know, the remaining cases, the cases related to Rose Hill, the Supreme Court decision, have finally been withdrawn. They were actually withdrawn this week. So that was Board of Appeals number 19-00211. The consolidated cases were under Doyle Land Partnership. It was a total of 16 cases. They have been withdrawn. You can have your sigh of relief that you're not going to have to hear 16 individual cases. So I just wanted to give you that update.
And we've already taken care of the two that weren't consolidated.
Yes.
One by a motion for failure to prosecute, and the other was the HEPR one that we did. So we're done with that. Yeah. Okay, and anybody else have any announcements? Then we are adjourned. All right. We did it.
I'll just note for the record, we're adjourned at 11:23. Thank you.